I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Donald Trump's lawyers have just filed an objection to the special master, Judge Raymond Dearie's scheduling order in the Mar-a-Lago stolen document matter. You'll recall that Judge Raymond Dearie was appointed as the special master in connection with Judge Eileen Cannon's improper assertion of equitable jurisdiction back on September 5th. That is currently being appealed in the 11th Circuit Court of Appeals. Judge Raymond Dearie is the judge who Trump recommended or suggested in his initial briefs, where Judge Cannon said that the Department of Justice and Donald Trump should submit respectively who they want to be the special master. Trump had selected Judge Raymond Dearie. The Department of Justice had suggested others. Judge Raymond Dearie was appointed, and Donald Trump and his lawyers have essentially objected to everything Judge Raymond Dearie is doing, because Judge Dearie, who's a federal judge sitting in senior status in the Eastern District of New York, follows the law, and the law is very clear here that you can't steal government records and claim that it's me, everything is mine. And these aren't complicated or really disputed issues here. I mean, Donald Trump, a former president, can't assert executive privilege and try to stop a criminal investigation by the Department of Justice, the current executive branch, from utilizing its own records. And Donald Trump has made a number of very frivolous claims regarding why these records should not be returned to the Department of Justice. And just for clarity's sake here, the Department of Justice has already received the 100 or so classified records back when the Department of Justice filed an emergency motion for stay with the 11th Circuit Court of Appeals and found that Judge Eileen Cannon's order regarding those records was improper, returning those classified records. So now we're talking about 11,000 other government documents that Donald Trump stole. Those documents are subject to the appeal that the Department of Justice has filed. But while that appeal takes place, Trump has just filed his opposition briefs in the Court of Appeals, which I did a previous video on, you can check out, but it's a frivolous opposition brief which rehashes arguments the 11th Circuit Court of Appeals has already rejected. A reply brief by the Department of Justice is due November 17th, and the Court of Appeals is going to make a ruling sometime thereafter. Unclear if they're going to hold oral arguments or not, but I believe there will be a ruling finding that Judge Eileen Cannon never should have asserted equitable jurisdiction in the first place, which would stop this whole special master process anyway, and all the documents would go back to the Department of Justice. But until that ruling happens from the 11th Circuit Court of Appeals, and Trump will inevitably try to go back to the Supreme Court, where he's previously lost regarding the classified records, and he'll lose again. But until that process is officially stopped, the special master's work continues. And so the special master issued a scheduling order on November 7th, and the scheduling order states as follows. Pursuant to paragraph 3 of the order appointing special master, the undersigned, meaning the judge, Raymond Dearie, intends to contact the National Archives and Records Administration regarding its practices and guidance regarding documents and the categorization of materials under the Presidential Records Act. Any party seeking to be heard in connection with this consultation may submit a letter of no more than 3 pages by November 10th, 2022. 2. An in-person status conference in this matter is scheduled for Thursday, December 1st, 2022 at 10:30 a.m. The undersigned anticipates that this conference will be an opportunity for the parties to elaborate upon their respective positions in advance of the report and recommendation to be filed by December 16th, 2022, signed by Special Master Raymond J. Dearie, November 7th, 2022, and entered on the same date. So the Department of Justice justice is fine with that. And as I said in the other video, what Judge Raymond Dearie recognizes is that these documents were stolen by Donald Trump. And what he wants to do is consult with the National Archives about how these documents are supposed to be maintained so he could issue appropriate recommendations. So Donald Trump and his lawyers objected to that. And what they objected to is that they said, well, the National Archives has been politicized. They're being run by Donald Trump's enemies. And as a result, any communications with the National Archives needs to occur in a formal hearing setting, and that you, Judge Raymond Dearie, should not engage in what's called ex parte communications with the National Archives, meaning we don't trust you, Judge Raymond Dearie, to have communications without us present because we don't trust you and we don't trust the National Archives. Not exactly the greatest argument to make before the special master, that you don't trust that the special master is going to be able to conduct himself in an ethical manner. And the briefing goes on to discuss traditional canons of judicial conduct, which in the normal course, and this is not the normal course where someone steals records, a judge is not supposed to have ex parte communications with anyone outside of the case. But this is a unique circumstance that Judge Raymond Dearie recognizes, where the real authority here is actually not the special master, and it definitely is not Judge Eileen Cannon. The law here vests the authority in these categorizations and how these documents are kept and maintained with the National Archives. So that's why Judge Raymond Dearie wants to speak with the National Archives. The National Archives is not a politicized branch. For Donald Trump, everyone is his enemy. Everyone's a rhino. Everyone's against him if you don't pledge loyalty to the MAGA extremist cult, which by and large Americans rejected during the midterm elections. And so Donald Trump saying, we don't trust you, we don't trust the National Archives, we don't trust anybody. And let's pull up the letter that Trump's lawyers submitted. By the way, if you notice one thing, it technically goes to 4 pages. So the judge asked for a 3-page brief and they submitted 4-page. Granted, it's the signature blocks on the 4th page, but the judge is very specific. I want 3 pages only, and Trump's lawyers didn't follow that. And this is what Trump's lawyers say to Raymond Dearie. They go, Judge Dearie, on November 7, 2022, Your Honor issued a scheduling order announcing your intent to contact the National Archives and Records Administration's NARA regarding its practices and guidance regarding documents concerning the categorization of materials under the Presidential Records Act. One way to read the order is that it contemplates on an ex parte or in-camera contact with NARA representatives. Plaintiff, President Donald J. Trump, okay, you're not the freaking president anymore. Stop saying that. Through the undersigned counsel, files this letter respectfully objecting to a private contact between the special master and NARA. However, plaintiff does not object to a process that allows full transparency and participation by the parties. In other words, we're going to object. Let's delay. Let's have a formal hearing where we call in people from NARA and cross-examine them under oath and try to turn this proceeding where we're talking about right now the documents that Donald Trump stole and the special master's tasks of ruling on Donald Trump's frivolous objections that certain documents are either personal or executive privilege, neither of which he can claim. Let's turn that whole process into a complete circus. So then in this letter, the next 3 pages are spent lecturing Judge Raymond Dearie on the canons of judicial conduct for federal judges and lecturing him about what his ethical responsibilities are, and essentially saying that Judge Raymond Dearie would be acting unethically if he contacted the National Archives. So then it goes on to the end and says, with these principles in mind, plaintiff respectfully contends that the special master should avoid engaging in an ex parte contact or otherwise conducting private interviews in this matter. Further, as noted during the initial status conference, the plaintiff has deep concerns regarding the political bias of NARA leadership. Accordingly, we must object to any contact with NARA that does not allow for full participation of the parties. And then they go on to say, plaintiffs suggest that a suitable alternative to an in-camera conversation with an interested party would be to call a NARA representative to appear at the December 1st status conference and provide sworn testimony to the special master and the parties. This would ensure the record includes all information developed in such testimony, and it would also allow the parties to ask questions of the representatives akin to a deposition. Plaintiffs' proposed procedure would appropriately balance the special master's need for information with the party's interest in testing the reliability and accuracy of that information. Thank you for your time and consideration of the matter. You see, Donald Trump's blaming everybody here. Oh, the National Archives are this politicized entity that's out to get me. No, they're not. What the judge just wants to ask NARA is just very simple questions about how they go about their categorization process, how they maintain these records to help inform his ruling on certain areas. Like, it's not a political bias issue and you want to turn the December 1st hearing into a trial, into a deposition. Look, Judge Raymond Dearie, I think is completely fed up with Trump and his lawyers. I'm not even sure after this, as a result of this objection, if Judge Raymond Dearie is going to reach out to NARA. I mean, he may basically say, look, I've heard enough. I'm just going to make the rule. If you don't want me to go to NARA, then I'm going to make the rulings on my own. And I was just trying to go to NARA to confirm certain things, but I have a pretty good, clear picture here that you stole these records, that your objections are utterly frivolous, and I'm going to rule against you. I mean, Judge Raymond Dearie has already scolded the Trump lawyers and admonished them in the last hearing and basically said, look, I don't want you playing these games in my courtroom at all. Where's the beef here? What are you even arguing? You're claiming that you stole the records, but now you're claiming that they're your personal records, or that you are claiming an executive privilege to stop the Department of Justice from accessing their own records. Are you kidding me? I mean, Raymond Dearie's already reflected that. And by the way, this isn't the first time that Trump's objected to Raymond Dearie. Trump previously objected to Raymond Dearie when Raymond Dearie tried to put forth a very organized way on a rolling basis that documents would be submitted to him and that he would review and make rulings on those 11,000 documents. Trump and his lawyers said, no, we want it to happen all at once. And Raymond Dearie said, why would we do that? Like, just on a rolling basis, submit me chunks if there are disputes of 100 disputes or 200 disputes. Because Raymond Dearie said, when you show up on December 1st, I don't know if you're going to have one objection or 11,000 objections. So I want this court and these proceedings to be organized. Trump objected to that and ran to Judge Eileen Cannon, and Judge Eileen Cannon ruled that it shouldn't take place on a rolling basis. And previously, Judge Raymond Dearie also requested at the outset that Donald Trump submit an affidavit under penalty of perjury and state in the declaration that whether or not the FBI's catalog of documents was truthful or not truthful. In other words, when Trump was spreading these conspiracies in his right-wing media appearances that he would do, to show in a court of law under an affidavit whether or not he's challenging that these documents are actually the documents at issue. Trump and his lawyers objected to that from Raymond Dearie. They went to Judge Eileen Cannon, and Eileen Cannon said, no. The only people here who need to submit affidavits under penalty of perjury are not the people who brought this ridiculous lawsuit in the first place, Donald Trump. Only the DOJ needs to submit the affidavits of their inventory log. Trump shouldn't have to say whether under penalty of perjury, those documents accurately reflect what he was keeping at the premises. So Eileen Cannon's bailed Trump out over and over again. And so we'll see what she does here if Judge Raymond Dearie says, well, I'm just going to contact the National Archives or whatever. I'm just going to make my ruling. But ultimately, what I believe is going to happen, no matter what, is the 11th Circuit is going to rule that Judge Aileen Cannon should never have asserted equitable jurisdiction in the first place. There's a test called the Ritchie test, which is, in the rarest of circumstances, can a judge intrude upon the Department of Justice engaged in a criminal investigation like this. And you have to find, under this Ritchie test, the case was called Ritchie in 1975, there's a callous disregard for the rights of the person being investigated, that the person would be caused irreparable harm, that the person has this urgent need for their documents back. The 11th Circuit's already reviewed that analysis with respect to the 100 classified records and said, look, Aileen Cannon, you didn't find there was a callous disregard for the rights of Trump. Your inquiry should have ended there. But in any event, Trump hasn't suffered irreparable harm. Trump doesn't have a need for the documents back because he stole them. He stole them. You can't claim irreparable harm and you need documents back that you stole. So I have no doubt that that same analysis applies to the other government records that he stole. And Trump filed an opposition brief to the Department of Justice's appeal. And basically he argued to the 11th Circuit, who made the ruling before, he essentially argued they were wrong in their prior ruling, that Ritchie test doesn't require a threshold finding of a callous disregard for Donald Trump's rights, even though the 11th Circuit then also analyzed the other factors in any event. And Donald Trump's lawyers argue that the 11th Circuit, you don't have any jurisdiction to hear this because this is not a interlocutory order or a final judgment, and you can't make a ruling. But the 11th Circuit's previously ruled under any reading of their jurisdictional capabilities, whether it's pendant jurisdiction, interlocutory review, or collateral rule or collateral order, they're able to make the decision. They have jurisdiction to hear the matter. So Trump is going to lose. So the question is, though, will the 11th Circuit make their ruling overruling Judge Aileen Cannon before December 1st or before this process concludes, before the special master, or not? But again, I have a high degree of confidence Trump will lose. But in any event, the Department of Justice has their classified records. They're pursuing the criminal investigation. They've granted use immunity to Kash Patel, which provides him limited immunity where they can't prosecute him for what his testimony is before the grand jury. They can still prosecute him under a derivative use immunity concept for other conduct that they independently gathered for Kash Patel outside of his testimony. Kash Patel could still be charged with perjury if he lied during his testimony, and Patel was compelled to testify before the grand jury. And so the Department of Justice is moving forward. And as I've also said, the midterm elections have left Donald Trump in a very vulnerable, very weak position because the MAGA mirage, which we've talked about here on the MeidasTouch network, was just that and never existed. Well, that bubble has burst, and people realize how weak and vulnerable he is right now. He doesn't have support. And so I think this also bolsters the prosecutor's confidence in being able to successfully prosecute him without the political backlash that they may be worried about. So that's the update. Another objection from Donald Trump of the special master who he selected. It never gets old. Hit the subscribe button right now. We're on our way to 1 million subscribers. We just passed 700,000 subs and are growing rapidly. It's free to subscribe. So please hit the subscribe button. And in addition, you can join our Patreon website. We'd love if you could become a patron. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. We're not funded by any outside investors at all. So none of the billionaire investors who fund the both sides media or the pro-fascist media. We're purely fueled by you. We're accountable to you and you only. And one of the ways you can help out and help grow this network is by becoming a patron, by joining one of the memberships there. You get lots of exclusive content on Patreon you can't get anywhere else. But most importantly, it helps grow this independent media platform. And I think we all know that this is so important based on what occurred in the midterm. So go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. MeidasTouch. I'm Ben Meiselas from the MeidasTouch Network. Until next time.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.